Good morning, everyone, and welcome to today's session on contingent labour, contractors, labour hire and employees. My name is James Matson and I'm a partner in the Workplace Law and Culture team at Bartia Perry. I acknowledge the Gadigal people of the Eora Nation and the traditional custodians of this land and pay my respects to their elders past, present and emerging. Today, I'm going to be joined by my colleague and the practice head of the Workplace Law and Culture team, Darren Gardner. Before we get started, I'd like to go over a few items so you know how to participate in today's event, which is being conducted over webinar. You will have the opportunity to ask questions anytime during the webinar by typing in your questions into the box found on the control panel, and we'll endeavour to answer your questions at the end of our presentation. You will also receive a copy of the slides of the recording post-event. We would also appreciate if you could fill out a short survey at the conclusion of the webinar. Good morning, everyone. And certainly on the last day of the month, 3 months of the year's already gone. It's already been an exciting year. Darren and I are glad to be able to present on a topic today that is quite fun for us law nerds and one of, I know, Darren and my favourite topics. It's also been interesting and I think it's fair to say a perpetual pain for HR, but it's also a topic that is often misunderstood but is an essential topic for business. How do you know the status and the rights and the obligations of your contingent workforce? And here we're talking about your casual and temporary workers and your contractors. Are they really who and what you think they are? Or is there a risk and a hidden liability lurking around the corner? Now, in the last 10 to 15 years, we've seen an evolution in this area of the law that has, to put it quite frankly, introduced uncertainty, greater stakes, and greater litigation and litigation cost. We have also seen businesses' models change, like the gig economy, only to be slowly eaten at and then brought back into the employment realm. So that brings us to today's talk and our agenda for today. What we're going to look at is 3 cases which have brought about a significant shift in that evolution of the law that we've seen taking place. We're going to talk to you about what the High Court has said in those 3 cases. We're going to talk about what it means for employment and other matters. We're going to talk about what these cases mean for the engagement of independent contractors. And we're going to deliver some key messaging and some key messages to take away from today. Now, before we get to the 3 High Court decisions, the focus of our seminar today, it is important that we pause and we look at where we were at, because even though we've been slowly evolving and us as lawyers have seen this happening, we'd also had a period where it'd be fair to say that there's been some consistency in applying principles in determining the status of worker. That included looking at the totality of the relationship and balancing and weighing up different indicia. Now, whilst that process may have led to different outcomes and been a bit frustrating, certainly there was a consistency in that we all understood the framework. But then something changed, and maybe it was the overuse of casual employees. Maybe it was the challenges that were being presented by the gig economy to people who see things in a traditional sense, as well as the perceived injustices of those matters, and indeed exploitation of workers. And indeed, there were cases where businesses were exploiting workers, and that then leads to what we then saw, which was the Fair Work Commission and the courts sort of pushing back, minimising reliance on the contract, minimising reliance on labels, minimising reliance on devices that are put in place. And we did enter a period of greater uncertainty in business and the engagement of models, so much so that Uber, who was successful in establishing that its business model was one of principal and contractor, in the Fair Work Commission, found itself before the full federal court under a battering of very tough questions, and quickly settled the matter to avoid an adverse decision. So we're coming up to this real push against this contingent labour workforce. And then that brings us to the three cases that come along to the High Court. The three cases which are going to be the subject of our talks today. So let me introduce them to you briefly. WorkPac arose in the context of regular casuals. The question is, what is a casual employee? In this case, it was a Mr. Rosato, who was engaged by a labour hire company under fixed term engagements, I think for 4 to 6 month periods. And under those engagements was doing 38 hours a week, was paid a casual loading of 25%, and as a result received no holiday pay, no entitlements that a permanent employee would get. And the question was, what was Mr. Rosato? And the full federal court said, well, when you look at the whole totality of the relationship, he was a permanent employee. Ignore the contract, ignore the labels, doing 38 hours a week, full-time work, week after week, contract after contract, he was a permanent employee. So that makes its way up to the High Court. Then we have personnel contracting, and this is going to be a case that Darren's going to talk about a lot more later. But to set the scene, we have a 22-year-old British backpacker, hops off the plane, coming from the airport, is looking for work as in a construction company, sees a labour hire company, goes in, gets told you've got to get a white card, you've got to get an ABN, gets given a services agreement, signs it with the labour hire company to perform construction work. And a little bit later on brings a claim and says, no, I was really an employee. And the building company or the host employer, which controlled the work on a day-to-day basis, the labour hire company says, well, that's the proof that he could not be an employee because we don't control him, and control's an essential factor of an employment relationship. And the full federal court reluctantly agreed. So that makes its way to the High Court. Then we have the case of ZG Operations, and this involved two employee drivers who in 1986 are offered by the company to be contractors because the company no longer wanted to employ drivers. So each driver goes off and creates a partnership, I think with their wives. They go and buy a truck, or the partnership buys a truck each, and they enter into contractor agreements with the company. The two drivers only drive for the company for 40 years. During that time, they wore the company uniform from time to time, even put the company's logo on their trucks. And the full federal court said they were employees. So off the company goes to the High Court. So that's how we get to the High Court. Now, Darren's going to look at those later cases, but I'm going to begin by looking at the WorkPac decision, and more importantly, what it means for business. So, casual employment. How do you know if an employee is actually a casual or a permanent employee? And we've probably gone through an evolution from the early 1900s to 2021. We began by saying, well, you know, it's irregular, intermittent, informal nature of the relationship that determines whether a worker is an employee, a casual or a permanent. Then when the Workplace Relations Act came along, we had a casual loading for casuals as part of awards, as part of a national standard. We moved to a circumstance where it was engaged and paid as such. So if you're engaged as a casual and paid as a casual, guess what? You are a casual. Then with certainly Rosado, and before that there was a decision of Skeen, the federal court moved it in the direction of saying, well, it's not labels, but it's the totality of the relationship. But by the time we got to the High Court, certainly the agreed position, at least under the Fair Work Act, was that a casual employee referred to an employee who has no firm advance commitment as to the duration of their employment or to the days or hours that they will work. So it sort of goes back to where we were at the beginning, but expressed as no firm advance commitment as to the duration of employment or the days or hours the employee will work. Now, that is a concept which the High Court was considering under the lens of the Federal Fair Work Act. A lot of what the High Court said in WorkPac, and indeed in the other decisions Darren talks about, will certainly be of importance and certainly cannot be ignored when one deals with the state system as well, for those joining us today who are from the state system. Now, what did the High Court ultimately do in this matter? It was significant. It was significant. We can go back to 2014 and we recall the High Court rejected an implied term of mutual trust and confidence in employment contracts for the whole fact that such a term brings uncertainty to business and employees, and the High Court being driven back then on the need for certainty for business and employees. Both parties should know for certain who and what they are. And as a result, what the High Court did in WorkPac was to say, well, we reject the approach of the vibe. We reject the approach of looking at the totality of the relationship, throwing the balls up in the air and saying, it looks like a pro heart, so it must be a pro heart. The High Court, importantly, recognised the freedom of parties to enter into a contract. for casual employment. The High Court recognised the primacy of the contract. And what the High Court said in WorkPac was you work out the status by and only by reference to legal rights and obligations. And what's the source for the legal rights and obligations in an employment relationship? It's the contract of employment. Now, it may also be legislation and an award and an enterprise agreement. So certainly those matters can't be ignored. But more likely than not, it's going to be the contract that determines it, absent some prescription in legislation or an award or an enterprise agreement, which can sometimes be lacking. So the High Court says contract is king. And that's a very significant shift we see from what, for at least the last 20 years, we've been dealing with the totality of relationship as employment lawyers, as employment and HR practitioners, because that's what we're being told to deal with. So what's the outcome then for Mr. Rosado? The outcome was that you look at the discrete contract at the time it was entered into, at the time the relationship was entered into. You don't look at the totality of the relationship and look at each individual contract and put it together with the conduct that's occurred. You look at the contract. And this arises in a context where, to put it bluntly, Parliament in the Fair Work Act had recognised the existence of long-term casuals. The existence of regular casuals had become a common feature. And in that context, there was no reason why a regular casual could not be a casual. So when you look at the contract, it was for the establishment of an assignment. Now that assignment might have been for 4 months or 6 months, doing 38 hours a week. But there was no ongoing commitment, no firm advance commitment of anything beyond that. And it was a matter for Mr. Rosado whether he accepted that or not. And in that context, in looking at the contract, it also provided for the payment of a casual loading in lieu of permanent entitlements. And the High Court said, well, that's a compelling indication by the parties that their relationship did not include a firm advance commitment, because if there isn't an advance commitment of ongoing work, guess what? You have leave entitlements. So when one looked at the contract that was entered into, in as much as he might have been doing 38 hours a week, that itself didn't carry the day, because when one had regard to the essential terms of the contract, he was engaged and paid as a casual because the contract said so. And that results in a big step back for certainty for all the parties in the relationship, knowing that set up correctly, set up clearly, the relationship is what the parties intended. So what's the lesson? The lesson is the contract. The contract is important. The contract is vital. And the contract needs to do these 5 things. It needs to describe the relationship as casual employee and as a casual employment relationship. It needs to be explicit about what the payment of the casual loading is for, and that there are no permanent entitlements afforded to the employee. those two matters are going to do a lot of work in carrying the day. It's going to be critical that you don't include anything in the casual contract that has the features of permanent employment. So avoid the temptation to have all the benefits of permanent employment, but treating it as casual. So you really need to be circumspect in what's in the contract. Make sure that there's no obligation on the business to provide any work or any amount of work to the employee. And equally, the employee has the right to not accept any work offered. That is sometimes hard for business to do, but it's an essential feature of casual employment. And what is critical, and this is going to be something that comes out through Darren's talk, but I think it is critical to include a self-serving comment in any contract that no conduct or work pattern can alter the contract or vary the contract. So in other words, yes, you're a casual, no obligation to accept work, but the fact that there might be a flurry of available work for a few months at 38 hours a week cannot itself be used to suggest that there's been a variation of the contract. And to be very clear that the contract can only be varied in writing as a variation of the contract. I think that's very important to protect the sanctity of the contract. And that's something over which business and HR needs to be very careful. Now, the other bit that I want to draw to everyone's attention before I hand over to Darren is, I think there's two other aspects that arise following work pack, which is important to keep in mind. And this also particularly flows given the cases Darren's going to talk about, but are particularly relevant to the employment area. It would be wrong to treat the High Court decisions as simply being in respect of casual employment, and perhaps casual employment only under the Fair Work Act. The decisions reflect the High Court really emphasising the importance of the contract to determining rights and obligations in an employment relationship, and there's no reason why that type of logic will not influence the way in which we examine fixed-term employment arrangements. So certainly there has been developments in that area where commissions in particular have been looking at reoccurring fixed-term engagements and suggesting that the recurring engagements might paint a different picture and enable a court to perhaps find there was ongoing employment because of a series of engagements. That now may require some shifting in thinking given the High Court focus on the contract and that determining the rights and obligations. So a good fixed-term contract is likely to hold its weight even if there are subsequent contracts. So that's quite important. The other thing that's quite important is going back to the early 2000s where policies were capable of being contractual terms and capable of being incorporated. Certainly there was a decision in Westpac which questioned whether that line of authority, which was giving employers significant exposure, was correct. And I think these High Court decisions give further weight to perhaps properly treating policies as other than contractual terms. And I think that is an area where probably businesses are going to get some more certainty in the future. So quite a significant decision from an employment law perspective. With that in mind, I'll now hand over to Darren, who can talk you through the contractor decisions of the High Court. Thank you, Darren.
Oh, well, thank you, James, and good morning, everybody. It's a pleasure to be here to talk to you about this. As James said, it's a very exciting development in employment law, and it's very unusual to have 3 High Court cases in the matter of months. And what the case of Rosato and work pack that James was talking about was a prelude to other decisions of the High Court in personnel contracting and ZG operations. So, and if you recall from the factual summary that James gave at the beginning, personnel contracting involves the British backpacker who arrives in Australia to get a white card to work in the construction industry. I think he got off in Perth and found personnel contracting as the labour hire business to find him work. ZG operations involved two, they used to be called lorry drivers, but truck drivers who were working for a lighting company, and that was Mr. Jemsek and Whitby, who operated through partnerships. Now, just to sort of start with a few notes, both of these cases concerned comprehensive written contracts. So think about the opposite situation as we go through these points, because certainly the High Court was aware that not all work relationships or labour and work relationships are fully documented. And it's understood that there may be situations where it's not possible to find comprehensive written terms defining the legal rights of the parties, which is what's important. And I'll talk a bit more about that as well, because that has some significance, certainly in for employers who engage people to perform work or provide services on, a simple letter, for example, or and rely on a body of other statute or regulations or award terms to hopefully sort of cover what's not dealt with in a letter of engagement. So that's important to note in these cases, that's what the High Court was dealing with in both cases. And also importantly, there were no allegations of a sham or an attempt to sort of define a relationship that at law was not what the parties were saying it was. So that again is an important consideration moving through this discussion, because that it still leaves open the possibility that if it's proven that there's a sham, well, it matters not what labels or how the contracts have come about at the time of formation. If the intention of the parties was something different and they're dressing it up, well, the law still can intervene and change and declare the proper character of the relationship. So just to the next slide. It's important here to recap on what for the last sort of 20 odd years has been the approach in looking at, is there an employment relationship? And that's based on a whole range of High Court decisions that actually have helped to define what's called the multifactorial or multiple indicia test. And whilst it was always true that the contract needed to be looked at first to identify the intentions of the parties, what courts would do is not to confine themselves to that contractual definition and look at the entire relationship or the totality of the relationship, balancing a number of different indicia as to whether it sort of looked more like employment or more like some other relationship that was not employment, such as agent principal, independent contractor principal, bailey, bailor, and so on. But the outcome of this process typically involves some impressionistic assessment. It was almost like a stirring in the waters and looking at the tea leaves at the end. And it's been recognised now by the High Court in both ZG operations and in personnel contracting that this can give rise to some uncertainties, and hence the need for many of these cases to have now being tested in the courts, because basically, if the parties can't be sure and have to rely on a court to interpret the relationship, that's not an ideal way of, defining what the actual nature of the relationship is. And also, whilst issues of control in the traditional multifactorial tests were important, they were not the only or primary decisive factor, and delegation and integration were other sort of integral sort of considerations, but often those involved a focus on the conduct of the parties after forming the contract. Again, that's difficult because that's a detailed factual analysis of everything that happens between the person providing the labour and the person paying for the labour, or providing the home for the labour to be used. So if you go to the next slide, what the High Court has now said in personnel contracting in particular is that this multifactorial test is apt to generate considerable uncertainty, both for the parties but also for the courts, which is an interesting and frank declaration that it's actually resulted in inconsistencies, including in these cases that had made their way up to the High Court, where a first instance judge, considering all the facts, was able to find employment, but then on appeal there's no employment, and then on appeal again there's a different outcome. And it's because of this problem of having to look at the conduct of the parties over the whole course of their dealings with each other. And you can imagine, for example, in the ZG operations case, the 40 years of truck driving for the company, that's 40 years of conduct. And interestingly, in ZG operations, one of the truck drivers, Mr. Whitby, had started out in a partnership, but then his partnership dissolved, which I think was a polite way of saying perhaps his marriage dissolved as well. And so he started during the 40-year period to provide labour through his own business. So again, there was a change in the relationship, not by a matter of contract, but by a course of dealings. And so, and also the High Court has interestingly said that using this multifactorial approach is not like using a shopping list where you tick down a list of items and everything has an equal weight. So although, and you might have noticed online, for example, the Fair Work Ombudsman has applied a tick the box sort of assessment of side-by-side analysis, and actually it's a common approach. The High Court's not saying that's not correct to do that, provided you're not giving every item equal weight. So what the court will do will certainly look at those different indicia, and but they may not, the court may not apply equal weighting to the tick and the cross. So, but the High Court's saying, look, just applying a tick and cross sort of method is in itself not a good way of determining it. It involves more weighing of different indicia compared to others. And also the High Court said, looking at the old authority of Stevens and Brobridge, Sawmilling and Hollis and Barbu, Stevens and Brobridge, the famous case involving loggers and logging haulers. Hollis and Barbu was the bicycle couriers from the 90s, was that when one person has done work for another pursuant to comprehensive written contracts, the court must still perform a multifactorial balancing exercise, and it may involve the history of dealings between the parties. However, that can only be done, it can't be done absent sort of a focus on the terms of the contract itself. So it's not, so if you've thought that these two High Court cases have said you throw out the multifactorial test, that's not correct. It's just that there's a warning here that the application of that test hasn't been correct and there's been too much of a focus on post contract dealings rather than what the contracts provide as the nature of rights that are created by the contract. So there needs to be a different focus on the contract. Just going to the next slide, which of course, as James had said, was revealed to us in WorkPack. So that finding had already been made, and so it was a reasonable prediction that personnel contracting and the High Court and ZG operations would also make that consistent finding, which it did. That is, the focus is on the contract first and the rights and duties and obligations under the contract. And it's through this lens that you then look at the various indicia. So that's the proper way to look at now the totality of the relationship. It's you need to look at first the contract rights and duties, and in fact the High Court and personnel has said it's only those all that the court can be focused on are legal rights and duties, not anything else. So what the parties intended, what they felt like it was, how it looked like from a third party looking in, they are not legal rights and obligations. The contract is the source of those legal rights and obligations, and it's not this impressionistic sort of looking through the hourglass sort of view of the world. And hence the emphasis in the quote there about looking at the contract's terms and how it defines rights and duties between the parties. That is the primary importance. And as James said, in WorkPack, it was also defined that it's the contract that was entered into between the parties at the time. It's not what happens over time, it's the contract that was formed. And particularly, this is particularly important where it's a comprehensive written contract. And the way that those contractual terms address things, such as, for example, how someone's going to be paid, whether they've got to provide their own equipment or will be given to them, their obligations to work and to whom, the hours, or is it being measured by a provision of services, delegation, all of those other issues which are indicia are still looked at, but through the lens of the contract and how that contract defines those obligations. So we go to the next slide. So that still means that indicia such as control, or the right to exercise control, and other indicia which have crept into decisions such as, is the person running their own enterprise or carrying on their own business, or are they merely providing labour for somebody else's enterprise, are still important. They're still important considerations. So if we look at that in the personnel contracting case, where the contract that the British backpacker entered into was comprehensive, and this is with the labour hire company. So his contract with the labour hire company did provide that he would be where he would work and for whom, and in fact the assignment that was relevant in the High Court was with the construction company Hanson. It provided for his remuneration and how he would be paid. It specified that he would be paid for labouring work, and in fact the documentation also described him as a self-employed labourer, which was an interesting label, but as I'll discuss in a moment, labels are not everything. But importantly, he would cooperate in all respects with the building client, but the labour hire company could terminate his employment if he did not obey their directions or the directions of the building client. So, for example, that's an important right because it's the right to terminate, and it's being specified by the labour hire company. So that's an important indicia, and given the degree of control, and it was found that the backpacker clearly was not running his own business or enterprise, but providing labour for somebody else's. He was found to be an employee of the labour hire company. That is, it matters not that the labour was being provided at a construction site somewhere in Perth for a client. He was actually providing labour to the benefit of the labour hire company so it could obtain fees for making available that labour. So that's another interesting assessment of how the contract defined rights. If we go to the next slide, in ZG operations, which again is the interesting case of the two truck drivers, it started off with a traditional approach of looking at how these two individuals who had actually started as employees in the business, but were then later asked to change the nature of their relationship to be contractors. They were required to purchase and operate their own capital, which was a truck. And in fact, they bought one of the, Mr. Jemsek bought a series of different vehicles over the time of the relationship. And he was responsible for the maintenance costs and operating expenses of that vehicle. Importantly too, this wasn't done, it was done by both through a partnership arrangement, so and it did involve their wives, but it did not matter that the wives were passive or were not contributing. That was an important sort of indicator of a different relationship, and that they were doing it as a business, not as individual employees. And whilst there had been there'd been a right to delegate, it had never been exercised. That was also indicative of contractor relationship. Now, as James mentioned, when it went to the federal, so that was the approach adopted at first instance. When it went to the federal court sort of focused on things outside the contract in many ways. For example, the fact that they were employees before they entered into the contract, that ZG operations as a business had superior bargaining power and they had no choice but to enter into this contractor arrangement. The fact that the drivers had worked for, over 40 years to the same business, although it had changed names. The drivers were wearing a uniform, and at times the lighting company actually asked them to display on their trucks the logo and business name, which was somewhat paid for by that lighting business as well. But as we've, that approach has now been rejected by the High Court as not focusing through the lens of the contract terms. So next slide, thanks. So, as we said here, the High Court's actually, despite what you might have read, that this is sort of a sweeping away of the past, it actually is an embracing of the past. And the High Court looked at a history of old cases where similar relationships had been analysed in the past, including truck drivers, different types of carriers and agents, and it was the High Court was comfortable in finding that these sort of indicia or these indicators were that of people running their own business. So the fact that they were contracting through a partnership and not themselves, and in fact had always conducted their business that way, including for tax purposes, and income that they received was split between the partners in the partnership. The fact that the contract required them to, again, it's the contract that required them to do this, and the contract that defined that they were engaging in as a partnership. The partnership was to purchase the capital, which in this case was a truck. The partnership was responsible for the expense, maintenance and insurance of the truck. There was an entitlement to a fee, but on provision of an invoice for delivery services for their truck and their consequential labour driving in the truck. They were entitled to delegate their services to another. They just never did, but they were entitled in the contract to do it. And whilst it was the contract was varied on occasions, including drivers negotiating higher fees. That was found to be consistent with a commercial arrangement where you could negotiate for a better payment for the services being provided. So the court concluded in this case that the drivers were running their own business and were not employees. It's a slightly controversial decision, I should add, because in New South Wales there's a contract of carriage jurisdiction which I believe would have applied to both individuals, but on my understanding of how the case was run, that jurisdiction was never contemplated. And so it's possible that somebody engaging in a contract of carriage similar to what Mr. Jemsek and Mr. Whitby were doing could still be caught by the New South Wales Industrial Relations Act contracts of carriage jurisdiction. But be aware that there are statutory powers to intervene in these sorts of working relationships. So in terms of, and this is an important sort of concept too, that the High Court in both cases said that, and also in WorkPac, that although a label may be of some influence, it's not determinative. And in fact, in both personnel contracting and ZG operations, not only were they not determinative, the labels used in the contract were actually found to be irrelevant. So although, you know, that's not to say that all contract descriptions of relationship are not relevant, and they can still be useful when interpreting the provisions of a contract, particularly if there's ambiguity in it. And as to the argument that the federal court applied in ZG operations about a superior bargaining power, the High Court actually found that it had no bearing at all on the meaning of the contract and rejected that entirely. So that's an interesting rejection of something that traditionally has been looked at by courts before these cases, and that is this idea of an inferior or superior bargaining power. It's often raised by, particularly by unions, as an indicator of employment if somebody does not have equal bargaining power, and that the High Court has basically said, well, that's not determinative at all. So that's an important finding. In terms of expectations we can have now following WorkPac ZG operations and personal contracting, I think what's important, and as was indicated in the WorkPac decision, this idea of looking at some amorphous or innominate hope of expectation falling short of some sort of binding promise enforceable by the courts is not a sufficient way of defining the relationship or the character of a relationship. And I suppose the High Court's now issued a warning to courts that you can't keep looking at conduct outside of a contract to try and determine the intention of the parties or what the nature of the contract is, in quotes, in reality, or which is often a term that's been used. It's, you know, is it in reality something? The High Court has, particularly in ZG operations and personal contracting, now said you need to look at the actual words of the contract and construe the contract in accordance with accepted contract principles. And this is not controversial. It's just that there's been a straying away from these concepts in employment law cases. And it's important to go back to those basic concepts and not to have this sort of expectational, impressionistic, or amorphous sort of view of assessing the nature of a relationship. Next slide. So as I said at the beginning, what if, so the defining nature of all three cases was that there were comprehensive written contract terms, but what if there isn't any such comprehensive written contract terms? Luckily, some members of the High Court recognised this, and in fact it was recognised that it's quite common for employment relationships or working relationships not to be well defined in written contract terms, and it's therefore still necessary to look at the totality of the relationship or the whole relationship, and so there's still a need to look at what terms the parties did put in place, whether it be in writing or it's also possible that there were oral terms agreed, which will be a matter of evidence. And then to still look at, it's not so much the conduct of the parties, but how the formation of those contract terms define relationships by way of legal rights, not expectations. So that's the important distinction, is what legal rights are understood to exist between the parties. And so it's in that context that there's a need to sort of put some primacy on understanding what the terms of the contractual relationship is. It's a moving away of, I mean, it's a recognition that we're certainly no longer in the days of master-servant, but we're certainly in the days of contracts of employment. And even the Fair Work Act and even the Industrial Relations Act in New South Wales recognise that at common law, there has to exist a contract of employment for there to be employment. So it's, again, it's not controversial, it's just a refocusing on back to basics. Next slide. So what can we sort of distill from all of this in terms of defining your work relationships with, particularly in terms of contingent labour arrangements, whether that be you're in a business where you're directly contracting with labour providers, or you're in a government setting where you're using procurement services, where the contract may have been sort of defined for you through a process, a government process. It's still critical now for there to be a good understanding of how comprehensive the contract really is, and is it a contract that, for example, and as James rightly said, does not permit variation by later conduct. We are suggesting now to clients that contracts need to have a clause, an express clause, to say that it cannot be varied by anything other than mutually in writing, and that's to avoid this idea that inconsistent conduct can vary the contract. Whilst you can use labels to help define what the relationship is and intended to be, they're not determinative still, and statements of intention or statements of expectation will not be sufficient, and it will still be significant if you have a contract with a corporation, partnership or trust rather than an individual. You need to be clear in the contract about the nature of the service being provided and the nature of the business benefiting from that service. This is again, a classic distinction of employment and contractor. Keep this in mind. If you remember anything today, and this is what the High Court focused on, a contract of employment is a contract for service, and a contract with an independent contractor is a contract for services. So the idea that you're in service in someone else's business is the defining aspect of employment, whereas if you're providing services business to business, you're not employed and you're a contractor. And there's still an importance in making sure, and this is the most common thing we often identify in contracts, there's an inconsistency within the contract itself about rights and obligations relating to the provision of a service rather than how the work is performed. So contracts that look at how the work should be performed, in what hours, and at someone's direction and in accordance with certain policies and procedures, is a dangerous way of defining what should be a services contract, where all you're interested in is provision of a service, and it might be that that service needs to meet minimum service standards, but it should matter not how the service provider performs the service, in the sense that if they have a better way of delivering the service that's cheaper, more efficient, and better quality, why wouldn't you be encouraging business relationships or commercial relationships that deliver the same service more efficiently, more cost effectively, and in an innovative way that could be better than someone else? That's the key difference. But it's often the frequent thing we see in contracts that muddies the waters. Minimise to the greatest extent any provisions that demonstrate control or the way that the work is to be performed, so that's that control issue. Include provisions that relate to delegation, rectification and insurance. That is, don't make it, if possible, specific to an individual. Allow them to be able to delegate work, and it might be subject to certain approvals and checks. Allow for, if there are deviations in the quality, timeliness or content of service, that there is a way to rectify that, and it's written in commercial terms to allow for rectification so that the service quality, content and timeliness of it measures up to the service standards you set in the contract. And make sure too that any terms about insurance are somehow, are not just there for dressing up, but they actually are there in real life, because it's a breach of the contract if there isn't. And having it there is also a demonstration that the person who's providing the service is not within your own business. They're working in their own, they've got their own business separate to you that should be separately insured. And then importantly, make sure the contract identifies legal obligations of contractors to provide their own equipment and be responsible for their own business expenses. Next slide. And key messages from today's discussion, and James, I welcome you to join in here too, but it is in brief that there's now a new primacy of contract, so contract is king, but with great benefit comes this responsibility to ensure that your contracts are well drafted, are consistent, and only deal with essential contractual rights and obligations, and they're not window dressed or made unclear by having things in there that don't look like contract terms or rights obligations. So they look more like expectations or something else. And ensure that those contract terms are consistent with the relationship you intend to have created at the time. And as I said, avoid contradictions of those terms, and which is the most common issue we find.
And Darren, the third point is an important point, because we've been asked a question about this, is that you've got to understand the difference between contractual rights and operation and policy. And what we tend to see a lot in these, particularly these contractor agreements, is businesses wanting to have the benefit of employment but not the obligations. And you can see contractor agreements with a lot of control written in there. And it doesn't need to be in the contract. And you've got to understand that there's a lot that can happen outside a contract that can give you the service standards you need, that can give you the level of service you need. So you need to keep the contract lean and mean. You need to deal with strict contractual rights and obligations, and understand that those expectations are separate. And then I think the last point is to make sure that you don't allow or adopt practices that permit variation or sham arguments to arise. So you got to be very clear. This is the contract, and it can only be varied by us sitting around a table and agreeing to specifically vary this contract. And anything else that happens doesn't vary the contract. This is the contract, and sticking to that contract. And employment is a difficult relationship, but equally difficult is managing a contractor relationship and making sure it stays a contractor relationship, and nothing has changed there in respect of those high court decisions. Now, please feel free to send through any questions. Certainly know it's close to 10 o'clock, so we'll only take a couple of quick questions. Certainly, Darren, someone has asked, you know, we would of course recommend comprehensive contracts now, but you know, what does a comprehensive contract entail?
Yeah, and it doesn't necessarily mean you need to have a 150-page contract for every engagement you have, but it needs to comprehensively deal with rights and obligations of the parties. So, and do it in a consistent way. So, for example, if you are going to the effort of defining the delivery of services according to whatever service standards you have as a business, you do not put in terms that give the service provider leave for holidays. So, I mean, that's just totally inconsistent. It should matter not whether the service provider, the contractor, is as an individual is sick, present, able, or on holidays. It's their business that needs to deliver the service, and it's up to them to decide how it should be done. And when you start putting controls, or this idea of leave is actually a permission to be absent, that in itself is just inconsistent with a contract for services.
And we've got another good question, and I think I know what this is tailored at, and the short answer is, and I'll give the answer rather than say the question. The short answer is yes. If you need to exercise control, and you're doing that because of safety considerations, you don't need to put that in the contract. You do it because it's an obligation that arises under statute, and that is something that can operate outside the contract, because the statute requires you to cooperate, coordinate in respect to matters of safety, and it's a matter of safety that impacts upon your workplace. You exercise that control outside of the contract. So you don't need to have a contract that is prescriptive on safety, because if you do that, a court's going to look at it and go, oh, well, the contract's exercising a bit of control here. What do we make of that? And you want to minimize that line of inquiry, because there will be part of the judiciary trying to regain some ground following this. So you've got to be alert to that. Now, there's another quick question. So would it always be inappropriate for a contract for services to require a contractor to comply with the business's relevant internal policies and procedures? Is there a better way to ensure they act consistently? So, Darren, do you want to?
Yeah, yes, I would say there is, in that you could require the contractor, as a precondition of the service arrangement, to provide to you their policies and procedures, and so that you can assess whether they're compatible. And that's quite common in contractor arrangements, including on issues such as safety. You would expect the contractor to have their own safe systems of work, and whilst you couldn't exercise control over the content and how it's done, you could certainly require that they provide proof that they do have them, and that you're satisfied that, you know, that's consistent with your obligations and the consultation and so on, that they've got an adequate system. Just as you would to say, well, look, could you also provide proof of your insurance? It's a due diligence thing. It's not saying you must. But once you start saying, well, look, our policies and procedures, which will no doubt talk about employees, they might talk about contractors, but once you start saying, well, you must perform these services within these strictures, and it's a term of the contract, you're running the risk of converting what are employment policies as a term of a contract as if it's an employment relationship.
And the big mistake, I was going to say, Darren, the big mistake personnel contracting made as well was to say you'll be terminated if you disobey instruction. Now, the fact is, with a contractor who doesn't have access to unfair dismissal, you can terminate on your notice provision. So you just have that in the contract. And if you can't say to a contractor, look, we would expect services at this level, so you're not dealing with it in the contract, you're dealing with it by way of your outside procedures, and the threat of termination looms over their head. You know, if the services aren't to the standard we want, we'll go get our services elsewhere.
Yeah.
I think that's a better way to deal with it.
Yeah, or an alternative is if you don't measure up with this, you've got 7 days to rectify and then we terminate. But I mean, that could be a variation, which is unusual because you don't normally have a 7-day rectification as an employee, but you could have commercial circuit breakers. But yes, it could be too that if you discover that they aren't complying with the law, you've got a right to terminate. And it's not because they're breaching your policy, it's because you've made an assessment that it's commercially risky to deal with them. All
right, so we'll wrap up there. Look, we can talk about this topic for ages, and there's a lot of work involved in these relationships to ensure that they are held correctly. Can I thank everyone for attending today? Wish you all the best. Look forward to engaging with you throughout the year. Thank you, everyone. Goodbye.
And feel free to let us know if you've got any uncertain arrangements that you want us to look at, because we'd be happy to do so. But all the best and take care.